Student Adrian Bisham, dear professors and students, queridas amigas y amigos. I am very honored to be here to share with you the Colombian experience in protection of socio-economic rights. And I am deeply grateful to the members of the Valerie Golden family and the organizing committee for opening a space to look at what is happening with law, rights, and judges in Colombia. Before focusing on social rights, allow me to share with you two experiences I had as a justice of the Colombian Constitutional Court. They touched my heart, but their lasting value resides in how they illustrate the complexities of interpreting the Constitution in Colombia. In 2007, the Constitutional Court extended to same-sex couples the right to formalize their marital union, which was recognized only to heterosexual couples in a 1999 congressional statute. Since then, hundreds of same-sex couples have formalized their unions. The decision of the court was a scandal in a Catholic country. The formalization of the marital unions has been discreet. Following decisions of the court have protected the social rights of same-sex couples to health and pensions, amongst others. After my 8-year term in the court ended, some justices were invited to a meeting of the Gay and Lesbian Association. They wanted to thank the court and other organizations, but it was the basic measure of their speech which moved me. The president of the association said, "Our dignity as human beings has been protected, and to preserve this achievement, we should exercise our rights with full determination, but without fanfare." They knew that their rights are part of a permanent struggle and that basic liberties may be lost even after they seem secured in the Constitution itself. In fact, there have been several attempts to amend the Constitution in order to exclude the justiciability of constitutional social rights and to cut the powers of the Constitutional Court in Colombia. In 2003, for example, the Minister of Interior of the time embarked in another attempt to amend the Constitution. In the midst of the controversy, we received an unusual request by indigenous communities from the South to visit the court. To our surprise, when they met the 9 justices at the so-called Palace of Justice in Bogota, they informed us that they had come from far away to protect the court and the Constitution against the reformers. For that purpose, the indigenous guard was with them. The guards only used big sticks, not to hit, but to create an imaginary wall to stop intruders to get into their territories. These guards would surround the Palace of Justice, where the court sits, to impede an amendment to the Constitution to be approved by Congress, which sits in a building just in front of the court. They also gave us, each of us, a bracelet woven especially to preserve our integrity. Guess what? It worked. The constitutional reform was never approved. When I listened to the indigenous chiefs explain to us the ritual they were about to perform, I was shocked to hear that an autochthonous guard created to protect their faraway territories had been, with great efforts and costs, transported to protect the Constitution. The indigenous knew that it was not a book they were protecting, but the constitutional space in which they have fought several legal battles and won without spilling a drop of blood. They cherished this constitutional territory very much, although it did not belong only to them, as their reservations do. In it, they also found respect for ethnic diversity and their cultural traditions. Our Constitution states that all cultures have equal dignity and enrich our national identity. The scope and intensity of constitutional judicial review of social rights that I shall describe may sound surprising and even incredible for those unfamiliar with Colombia. In a country associated with political violence and the drug trade, an active judiciary involved in the protection of social rights may seem strange. Thus, allow me to refer briefly to some features of the Colombian context. Then I will concentrate on the judicial protection of social rights and the debate generated by the decisions of the Constitutional Court. Our context is like the goddess Janus. It has two faces. It is as if there were two countries, one where force reigns, another grounded on the rule of law. One in where some persons have survived apparently unsurmountable suffering, another inhabited by last year's second happiest people in the world, according to some happiness index. I shall not attempt to describe or to explain this paradox. I shall only recall a few basic facts. Colombia has approximately 50 million inhabitants, a bit more than Argentina, while guerrilla and paramilitary organizations gather 50,000 armed individuals at the most, after partial demobilization of most paramilitary groups. These organizations operate mainly in the rural areas of a very big country with around 75% of urban population. Colombia has held regular, periodic, and free elections for Congress and territorial authorities for over a century, as well as for electing directly the President of the Republic since 1910. Even though the Constitutional Court was created in 1991, constitutional judicial review has been a constant feature of the Colombian system. Active judicial review of legislation by the Supreme Court operated continuously with more or less intensity since the end of the 19th century. The Supreme Court first invalidated the statute on July 6, 1887. This was our Marbury versus Madison, if you want. Since then, only 3 years have passed in which no legal provision at all has been invalidated. Colombia has the second longest tradition of uninterrupted independent judicial review in the world after the United States. The creation of the Constitutional Court in 1991 represented a profound institutional change which was not nevertheless compatible with the Colombian tradition of active judicial review and judicial independence. The new constitution was brought to life by a constituent assembly summoned by democratic elections in 1990 and very pluralistic and diverse in its composition. The 1991 Constitution was adopted to respond to several profound structural Colombian problems: historic injustices against ethnic minorities, poverty and inequality, as well as arbitrariness and human rights violations. The generous and progressive Bill of Rights expresses this aspiration and protects all kinds of rights, including socio-economic rights. In 1991, the Supreme Court lost constitutional review powers altogether. The Constituent Assembly not only created the Constitutional Court, but in addition introduced several reforms that made it even easier to access the court and expanded its jurisdiction in both abstract and concrete judicial review. I highlight only the most important one, known as tutela. Tutela is a writ of protection of fundamental rights. A tutela may be brought forward by any person before any judge with territorial jurisdiction in order to prevent or stop the violation or her constitutional protected rights. A maximum term of 10 days is granted to the judge for deciding a tutela in first instance. Judges can adopt any measure deemed necessary to protect fundamental rights in accordance with the specific requirements of the case. In addition, every single tutela judgment adopted in the country may be appealed before a higher judge and in any case reviewed by the Constitutional Court, which will at its total discretion select those that it regards worthy of a judgment by the court. Access to the court is thus very easy in Colombia. Colombia has perhaps the most open system of judicial review. There are 4 mechanisms of access to the court, in addition to tutela. I will mention only one: the unconstitutionality actio popularis, created in 1910 and used since then by any Colombian citizen as an individual political right. It triggers abstract judicial review to challenge in the abstract any statute adopted by Congress, and decisions of the court in these cases have erga omnes effects. Thus, the Constitutional Court has issued judgments on nearly every aspect of Colombian life. I will concentrate now only on some of the cases concerning the protection of social rights. It all began with the principle of dignity, the underlying force of the 2 anecdotes I mentioned, and for some, the common basis of all rights. In 1992, an old man complained for the delay of the Public Social Security Agency to respond to his petition for continue receiving the pension of his spouse after his wife died. He was ill, did not have work, and lived alone. He filed a tutela against the corresponding state agency. The court considered that it was not the right of petition which was at stake, but a new right, closely linked to human dignity and interrelated to all social rights, the minimo vital in Spanish, or a right to a minimum level of subsistence. The court said, I quote, "Even though the Constitution does not acknowledge a right to subsistence, the latter can be deduced from the rights to life, to health, to work, to public assistance, or to social security. The person requires a minimum of material elements to subsist." I continue quoting the court. "Any person has the right to a minimum of conditions for his material security. The right to a vital minimum, the right to subsistence, as the petitioner calls it, is a direct consequence of the principles of dignity and the social state based on the rule of law." The same year, another case reached the court. This time the plaintiffs belonged to a poor marginalized community, the Vista Hermosa neighborhood in Cartagena. The public works to build a sewage system were left unfinished. This resulted in the neighbors having to put up with the overflow of wastewater, noxious smells, and environmental contamination. The plaintiffs filed a tutela asking for the sewage works to be completed, Of course, there is not a constitutional right to the adequate construction of sewage systems, and to finish the public works would cost money. Nevertheless, the court protected the dwellers' rights to public health, human dignity, and life, and ordered the Public Service Company of Cartagena to finish the construction of the sewage system in 3 months. In this decision, the court elaborated on the doctrine of connectivity between rights that are not fundamental and rights which are. When there is this connection in the concrete case, social rights, in this case the right to adequate sanitation, become justiciable, the court said. As the issue of the resources but was not the court creating a remedy in a field within the sphere of competence of the legislator? If Congress had not regulated the access to sewage systems nor created solutions to unfinished public works in a poor country, could the court invade the legislature's domain? The court addressed this separation of powers issue in the following way. I quote the court. In this specific situation, the absence of a solution by the branch of power entitled to act opens the possibility for another branch, in this case the judiciary, to decide with the sole objective of safeguarding the validity and effectiveness of the relevant constitutional provision. The court continues, affirming that social, economic, and cultural rights are merely a link of political responsibility between citizens and Congress, is not only naive with respect to the existence of such bond, but also flagrant distortion of the meaning and coherence which the Constitution must keep. If the responsibility on the effective realization of these rights were exclusively in the hands of the legislature, constitutional provisions would have no value, and the validity of the will expressed by the Constituent Assembly would be subordinated to the legislature's volition. Since these two decisions rendered in 1992, social rights are justiciable in concrete cases in Colombia by 2 ways. First, if in the circumstances of the case, the right to a minimum level of subsistence is being violated. Second, when a connection between a fundamental right and a social right can be demonstrated, also in the circumstances of the case. In addition, there is a third way to protect social rights in concrete constitutional cases. The court can conclude that a specific social right is fundamental in itself, not because it is in connection to a fundamental right or to the right to the minimum level of subsistence. The court opened explicitly this door in a safe case, the right of children to health. It did so in the vaccination case. Can a tutela judge order the direct application of the constitutional right to health if there is neither a congressional act nor an administrative regulation concerning vaccination programs for children? No, 3 justices answered. Social rights require the previous intervention of the legislation to define their scope and beneficiaries, the policies to protect them, and the public resources to finance the corresponding programs. Fortunately, the remaining 6 justices considered that in certain circumstances, the judge can order the immediate and direct application of a constitutional social right. In this case, the majority of the court highlighted some of the salient features of social rights. The court said, for instance, that these rights have a twofold content: an essential, non-negotiable nucleus that may be not restricted, and a progressive development area that the extent and content of which is to be defined through democratic debate and is essentially tied to congressional statutes and administrative regulations. The court also stated that when the subsistence of marginalized or weak groups and individuals is at stake, the constitutional judge cannot leave their protection to future hypothetical legislative action. That is the case of children in poor neighborhoods, even in the capital of Colombia, Bogota, who are not able to participate in the political process for the definition of priorities and the assignation of scarce public resources. Then the court analyzed whether the vaccination requested was part of the non-negotiable nucleus of the right to health. Since the vaccine was against meningitis, whose impact on children can be devastating even more in a social context in which it can be easily spread to other children, the court concluded that it was within the basic nucleus. Finally, the court found that the authorities had failed to prove that it was impossible for the state to implement and finance a vaccination program in this area of the country. Therefore, the lack of a public policy in this respect was constitutionally unjustified. Thus, the court ordered the municipal authorities of Bogota to institute and fund an infant vaccination program for poor children. In the last decade, the judicial protection of social rights has had unsuspected developments. Some see them as a magnificent crescendo in a constitutional symphony. Others criticize them as strident notes incompatible with basic tenets of constitutional interpretation. Here is the magnitude of the crescendo. In 1992, when less than 10,000 tutelas were filed in the courts all over the country, social rights were barely present in constitutional litigation. The right of petition and due processes were more important, as well as other classical liberties. In 1998, the only year of economic recession in Colombia, social rights became the most invoked in the 40,000 tutelas decided by the judges. In 2000, more than 100,000 tutelas were decided all over the country. In 2005, the number reached 200,000. Last year, 358,000 tutela judgments were sent by the judges to the Constitutional Court to be reviewed. Tutelas concerning social rights amount to 40% of the almost 1.5 million tutela judgments rendered in the country during the last decade. Most of them relate to the right to health and pensions. But it is in the qualitative terms that the impact of the judicial protection of social rights can be assessed. Almost every social right has been protected by the court. The right to work of street vendors, since if they have worked with de facto acquiescence of authorities, they cannot be expelled from public space unless a reasonable alternative of work has been offered to them by municipal authorities. The right to education of children, since their rights in school cannot be denied on the ground that the parents did not pay the monthly tuition or fees to the school. The right to housing for families who live in unstable lands, since the municipal authorities must offer them a reasonable alternative and cannot force them to move until the alternative is really available. The social and economic rights of informal waste pickers, since municipal authorities have the duty to verify and ensure their affiliation to Social Security and local social programs, as well as to allow the formal waste pickers to compete with formal corporations in the business of waste recycling. The list go on and on for too long. Let me share with you some of the basic issues of our constitutional debate and how the court has addressed them in the field of social rights. The first heated debate was raised by the private sector. It concerned the cost of social rights, mainly the right to health. In Colombia, most health insurers are private. They insure a limited set of benefits defined in a health plan, adopted by a public regulation issued by a regulatory agency. Each insurer receives a fixed amount of money per each person affiliated to the insurance company. The resources to finance the benefits come mainly from a payroll tax. Some argue that if the benefit was not covered by the finance health plan, the court should refuse to order the health service requested. The court explained that a right does not cease to be a right because it has a cost not covered. Then the question arose, who pays for a health benefit not covered by the limited plan if the patient does not have the money, as usually happens with high-cost treatments? The court faced carefully this question in a case concerning the financing of AIDS medication. Several people living with HIV/AIDS had filed tutela writs requesting the delivery of medication required for the treatment, but not listed in the health plan. In a unanimous decision, the full court protected the claimant's rights. In those cases in which a prescription had been issued by the competent physician, the court ordered the insurer to provide the medication. But in addition, the court also responded to the insurer's concerns. It authorized the insurer to petition the state in order to recover the cost of medications not covered by the health plan from resources allocated in a Solidarity Public Fund already created by Congressional Act. The court also ordered the Ministry of Finance to implement the Congressional Act in which it was mandated that a specific percentage of resources coming from the national budget be assigned to this fund. The problem of costs could not be addressed by the court in the same way when other social rights were involved, since there is not a solidarity fund for each social right. Thus, the court finds different solutions depending on the circumstances. For example, it has given the competent organ a sufficient delay to appropriate the new resources needed to implement the order of the court. Or, it has ordered the competent organ to design an action plan in which one of the tasks is to find funding for the programs needed. In this way, the court has also given some bite to the concept of progressiveness. The idea that social rights should be gradually extended to give wider and deeper protection to more people in accordance with the available economic and administrative possibilities of a country. Basically, the court says gradual extension means advancement. not indefinite postponement or permanent paralysis. Available resources means that if today there are no resources, the competent organ must have a delay to find them. Not that it can be argued forever that there is not enough money to implement social rights. Since the tutela judge has freedom of remedies, it can create a solution appropriate for each case, taking into consideration economic concerns and limited administrative capacities. But in some cases, this is impossible, and the court has had to face very tough decisions with immediate economic impact. This usually happens in abstract control of legal norms, mainly congressional acts challenged via an actio popularis. The most controversial cases had to do with the system of credits and mortgages to finance the acquisition of a house. The system was based on a scheme of constant purchasing value units, or UPAC. For complicated historical economic reasons, the system had reached a point where it was not only inefficient but also counterproductive because value units were calculated through annual variations in the interest rates, which were constantly reaching new historical peaks. This contravened the government's original objective and made social housing debts too high to pay. Very few dared to contract a loan with a bank to buy a house. Moreover, thousands of Colombians lost their houses at the end of the 90s, but the central bank kept rising interest rates, applying the legal framework in force. The court reviewed the constitutionality of these regulations, challenged by several citizens, in 3 decisions that caused an unprecedented level of debate. The decisions are full of technical arguments and very complex. In sum, in 1999, the court, with 2 dissents, protected the right to housing in several ways. First, it prohibited that the variations in the value of UPAC units should always be tied to the ups and downs of interest rates in the financial sector. It did so by striking down the congressional statute that tied them, and by entrusting to the central bank, an autonomous constitutional organ, the power to regulate the rates for housing loans. Second, it highlighted other features of the system to finance access to housing and concluded that they were manifestly irrational, since in the context of recession, rising unemployment, and increasing interest rates, most debtors were losing their houses. Thus, the UPAC system was as a whole being a barrier to access housing. Third, on procedural grounds, it struck down the entire basic regulation of the system and gave Congress 6 months to design a new, adequate system. Banks had to revise each individual debt to conform to the court's decisions as well as the new system designed by Congress. The real value unit system, as was called, later upheld by the court with some conditions. Huge amounts of public resources were assigned to alleviate the transition from one system to the other. These 3 decisions prompted a new kind of debate, this time about the macroeconomic impact of constitutional judgments. Should the court abstain of protecting a social right if the judicial intervention would have an impact in the whole economy and generate a pressure on the national budget? How can constitutional restrictions be reconciled with budgetary restrictions? The court tried to solve this dilemma in abstract review of statutes cases, mainly by postponing the effects of its judgment, and thus given to the legislature more time to reform statutes held unconstitutional. The court authorized that for as long as 1 or 2 years, an unconstitutional statute continued to be enforced while Congress designed a new statute compatible with the Constitution. The most difficult case concerning the macroeconomic impact of constitutional decisions was decided in the year 2004. We call it the IDPs case, the internally displaced persons case. In it, the court did not strike down any statute. It decided to protect all IDPs in Colombia. Before this decision, the court had protected individual IDPs on a case-by-case approach, granting the tutela. Individual IDPs ask usually for humanitarian aid, which includes food, clothes, some kind of shelter for 6 months, according to the programs in force at the time. Some ask for priority in access to housing programs already being implemented, or to access to education and health services in the place of arrival. But this individual approach proved to be totally insufficient in the face of the magnitude and complexity of the problem. around 2.5 million IDPs at the time of the decision, 3.3 million by the end of 2009, according to official statistics. NGOs consider that at least 1 million IDPs are not officially registered. 50% of all IDPs are under 80 years old. Most IDPs are women. Some indigenous peoples are facing the risk of ethnocide. Afro-Colombians living in the territories near the Pacific coast are under pressure to leave their lands. The main cause of internal displacement has been armed conflict, especially illegal armed actors. It is a humanitarian crisis which intensified in the 90s and continues until now. In 2004, the court cumulated over 100 tutelas filed by IDPs all over the country and rendered the most costly decision ever adopted by the court and the one with the biggest macroeconomic impact. But nobody complained about that, not even the Minister of Finance. Why? Because of the kind of remedy designed by the court. The design of the remedy also appeased other aspects of the debate concerning the protection of social rights. The court concluded that all the constitutional rights of all IDPs were being disregarded in a massive, protracted, and reiterated manner. These generalized violations were due to structural failures of the government, seen as a whole and over time. Thus, the court held that there was an unconstitutional state of affairs. The concept of an unconstitutional state of affairs was created by the court to deal with the structural causes of massive fundamental rights violations, as was the case of the living conditions of prison inmates. But in the IDP's case, the implications of the unconstitutional state of affairs were enormous. The structural problem was caused, according to the court, by the deep gap that existed between what the law promised to the IDPs, on the one hand, and the scant financial resources allocated to protect and assist IDPs, as well as the state's precarious institutional capacity to implement public policies on the other hand. The court not only protected the individual petitioners, but went even further to protect all IDPs, present, past, and future. It imparted a number of structural complex orders aimed at overcoming the unconstitutional state of affairs, mainly the following. The court ordered the national and territorial entities to adjust their budgets and programs in order to close the gap between their commitments concerning IDPs and the level of resources allocated and their institutional capacity to act to protect IDPs' rights. They could do it autonomously and gradually, but within a predefined timetable that should be publicly announced. The court, following the UN guiding principles on IDPs, established minimum mandatory levels of protection of IDPs' rights. Third, the court ordered that in the adoption of the decisions aimed at overcoming the unconstitutional state of affairs, authorities were to provide the organizations that represent IDPs effective participation in decision-making. And fourth, since the orders amounted to a huge and costly reform, the court said that should the government identify the need for a redefinition of the legal framework in force since 1997, or a modification of the state policy on account of budgetary restrictions, it would have a term of 1 year to think about it. After 1 year, the government could make a public statement announcing that it was impossible for the government to fulfill its legal commitments, and thus it would amend them to diminish its obligations. But this could be done only if the government passed a strict test to justify regression in the protection of social rights. Fortunately, the government opted to maintain its commitments and decided to increase significantly the budget for IDPs programs and embark in several reforms. Finally, the court retained its jurisdiction over the case. In the last 6 years, the court has monitored the compliance with its decision and has issued over 50 follow-up decisions after evaluating periodic reports submitted by the government and assessing the opinion of IDPs organizations and oversight independent agencies. After this decision was rendered, the court had to tackle with a very complex follow-up and monitoring process. First, There arose the problem of how to measure the progress achieved by the government in overcoming the unconstitutional state of affairs and build durable solutions for IDPs. It took 2 years for the government to admit to measure its performance by result indicators, not process or effort indicators, and to design such indicators based on the effective protection of human rights. The court pushed hard, if I may say. It required for such indicators to measure, as I say, the effective enjoyment of rights by IDPs on the ground. The government had to show how many IDPs were actually being protected in practice at moment zero, and how this protection of rights improved and expanded over time due to compliance with the orders imparted by the court. A commission created by civil society with the participation of IDPs was invited to apply by itself these indicators in the field and submit an independent report to the court. The Commission did a national survey and thus obtained more accurate, valuable, and balanced information than the government itself. Second, there was the issue of whether the general policies adopted by the government were adequate to protect especially vulnerable IDPs, such as children, women, disabled, elders, indigenous peoples, and Afro-Colombians of the Pacific Coast mainly. The government argued that they were, but several NGOs thought otherwise. The court convened several public hearings in which governmental authorities had to explain to the IDPs themselves, face to face, why these general policies were really sufficient. The hearings were not only revealing of the shortcomings of the general policies, but also deeply moving. The authorities ended up explaining why they had not been able to reach the most vulnerable groups. The court judged this approach insufficient and decided to issue several follow-up decisions, one for each especially vulnerable group of IDPs. In separate decisions, it ordered the government to take into account the specific risks faced by each distinct group, as well as their specific needs, and to design new programs to address them. The court ordered that the design of these programs be done with the effective participation of IDPs. For example, concerning ethnic communities at risk, the court ordered the design and implementation of a rescue plan for each community with the participation of their respective community leaders. Someone may think that judges should not do that. It is too much intervention in the spheres of other branches of government. Nevertheless, the government has not argued that until now. The court has not done what the government must do. It has ordered the government to act and design solutions. Moreover, the judicial remedies were structured to generate legitimacy or acceptance of the new steps given. For example, the government could not complain of the fact that it had to spend much more money on IDPs, because it was the government itself who estimated such increase and decided not to regress in its obligations towards IDPs within the delay of 1 year given by the court. NGOs friendly to the cause of IDPs ceased to demand immediate housing for every IDP family and took on a greater challenge to propose how to find durable solutions for housing for 2/3 of IDPs that do not want to return to their original residence out of fear. What have been the results of all this? I mention only a few. Since 2004, the national budget for IDPs was multiplied by a factor of 8 in fixed dollars. Public policies are being reshaped by the government towards the protection of rights. Significant progress has been achieved concerning the health of IDPs, since around 79% are affiliated to Social Security and health. And education has also increased coverage. 80% of IDPs' children go to school. Objective criteria, result indicators to measure policy results have been adopted, inspiring the effective enjoyment of IDPs' rights. And all relevant actors are now aligned to move in the same direction, the protection of IDPs' rights. I also want to highlight that other aspects of the debate concerning the judicial protection of social rights were addressed by this decision in the Colombian context. First, the categorical distinction between rights, for example, civil, political, and social rights, and the lesser importance assigned to social rights. The court showed that for IDPs, all rights were equally fundamental and all were interrelated and could not be separated. Second, the negative dimension of liberties as opposed to the positive dimension of social rights. The court underlined that freedom of movement has a positive dimension if you are chased from your residence, and the state has the obligation to adopt measures to protect at least your ability to move safely until you reach a safe town. The right to food has negative dimensions. Peasants expelled from their lands from which they obtained their food are deprived of their social right to food they were enjoying. Third, the deficient capacity of judges to understand social problems and design social policies. The court did not supplant the government nor the social policy experts. It ordered the competent organs to explain the complexities of the unconstitutional state of affairs and then to propose solutions. It challenged the government, if I may say, to be transparent, creative, and effective, and prompted the competent organs to explain in hearings why public policies were really protecting constitutional rights or were missing this paramount objective, and what they will do to correct mistakes or overcome barriers. Although there has been a broad consensus concerning the court intervention in the IDP's case, some believe that the court went too far in a more recent judgment. I do not think so. It is a 2008 decision protecting the right to health, this time the right to health of the entire Colombian population. Let me finish returning to the right to health. As was mentioned, the right to health as a social right was protected in concrete tutela cases whenever in connection with the fundamental rights to life, integrity, and dignity. But over time, as health cases became the most frequent ones, it was clear that a case-by-case approach was also insufficient to effectively protect the right. The court, in 2008, found first that the right to health was an autonomous social fundamental right, as some tutela decisions had previously but timidly said so. And second, that the violations of this right were not only due to the refusal of some health insurers to authorize the health services needed by the patient according to the competent physician, but also to structural failures in the health system. Then the court derived the consequences of both conclusions. It is a very lengthy decision whose main aspects can be summarized in 4 holdings. First, the court found that the frequent use of tutela invoking the right to health was due to regulatory failures on the part of the national agency responsible for designing the health plan covered by insurance. The court thus ordered these failures to be solved. The orders include the redesign of the health plans in accordance to health priorities. These priorities should be defined through participatory means, applying transparent criteria, and be based on public health epidemiological studies. Second, since the health plan for the poor was significantly more reduced in the services covered than the plan for those who had economic capacity to contribute to finance the system through a payroll tax, the court ordered the adoption of one new basic plan equal for all, comprising the services with high priority. Those with capacity to pay could have access to a complementary plan, including health services of lesser importance. Third, the court ordered the gradual universalization of access to the health system. Although since a 1993 statute there had been an important improvement in this respect, still large portions of the poor were not effectively covered by any health plan. Fourth, all the above decisions should be supported in studies about the financial sustainability of the new health plan. Fifth, the resources to finance the system should flow easily and rapidly to the private or public insurers to which patients are affiliated, as well as to the hospitals that provide the required services. Due to red tape and fiscal pressures and other factors, a large portion of these resources was invested in bonds by the government and arrived very late to finance the health system. As it did in the IDP's case, the court retained its jurisdiction to monitor compliance, ordered the adoption of indicators to measure results based on the effective enjoyment of right to health, and requested periodic governmental reports by fixed dates. If by the fixed dates the government did not provide solutions to the problems that resulted in the violation of the right to health, a subsidiary and transitory solution established by the court had to be applied. The government could ask for a postponement, but the proposed new dates had to be carefully and subtly justified by the government itself. The decision prompted an intense controversy. The government, for example, complained about the costs and the difficulty of designing a broader health plan that would include all Colombians. On October 1st, 2009, the responsible regulatory agency adopted a unified health plan for all children under 13 years, instead of redesigning a new basic plan common to all kids. The court extended this plan to minors under 18 years, since this is the constitutional definition of children. It is an open question whether for adults the government will do the same, blunt unification of plans, and refuse to redesign the health plan as the court had ordered. Others argue that the delays were too brief to define health priorities through the participatory process ordered by the court, but the court has not received sufficient arguments to postpone the delays originally fixed. Moreover, there is still a long way to go in ensuring a rapid flow of resources from the Solidarity Fund to the system. After more than 1 year, the government realized that there was a need for more resolute action. At the end of last year, the President of the Republic declared a state of social emergency in order to adopt exceptional legislative measures to solve some of the problems underlined by the court, supposedly. The measures initially revolved around new ways to gather additional funds to finance services not covered by the health plans, mainly taxes for beer, lotteries, and betting games. More recent presidential decrees, nevertheless, are aimed at restricting the scope of the right to health, making very difficult to access services outside the health plans, which have not been expanded nor redesigned yet. All the decrees are being reviewed by the Constitutional Court and have raised a very intense controversy. In the IDPs and health structural failures case, the court assumed a position of what I called prudent activism. Of course, there is activism in these decisions, but the court's strong interventions are aimed at generating a situation in which the competent executive or legislative authorities must act to fulfill their duties in a context of a more mobilized stakeholders, and shall focus their decisions to the aim of ensuring the effective enjoyment of social fundamental rights as well as other constitutional rights. The judicial duty of protecting social rights has led the court to walk near the cutting edge of a cliff, but it has resisted the temptation of jumping and trying to fly over a precipice. Is it too risky? It is another Colombian paradox that the steps taken by the court to protect social rights have strengthened the court's legitimacy. Call it constitutional magical realism if you love Garcia Marquez. The court has used this legitimacy as a stronghold to adopt very controversial decisions on other topics, such as decriminalizing abortion in certain circumstances in a Catholic country, declaring unconstitutional presidential emergency decrees aimed at fighting terrorism in the midst of an armed conflict, reaffirming that human rights and international humanitarian law must be respected by all executive authorities, even striking down constitutional amendments. Taking risks on the side of fundamental rights is a judicial duty in a context of horrid human rights violations, pervasive inequalities, and rooted social exclusion. I was convinced of that after listening to a peasant woman 4 years ago. Although she had never finished high school, she was an eloquent and passionate leader of IDPs. She told to the audience something that made me remember a famous American statesman. The peasant woman said, "I am grateful to war because suffering has transformed me into a citizen and made me conscious of the significance of fundamental rights." Then she invited all women present to stand up for their rights and the rights of their kids and elder parents they had to care for. I replied, being the panel, I shared with her that Thomas Jefferson had said once something in the same spirit. The tree of liberty must be refreshed from time to time with the blood of patriots and tyrants. She was neither impressed nor flattered by my comment, having cried after seeing the spot of blood of her relatives. But she was happy to know that in Colombia, some lawyers say that tutela embodies the right to permanent and continuous peaceful rebellion against arbitrariness, and that rights, all rights, notoriously social rights, are conceived as tranquil weapons in all sorts of institutionalized battles for human dignity, equal liberty, and social inclusion. Thank you very much. Thank you very much. Thank you.
Thank you so much for a terribly inspiring presentation. So we have about 15 minutes for questions and comments from the audience, and then Adrian will make a presentation to Justice Cepeda, and then we'll hear from our most favorite alums, Chris Lamar. So the floor is open.
Any questions, Judge, about thank you very much. And you mentioned earlier.
Yes. Basically, the court ordered that these medical services be provided, even though there was a debate concerning whether the health plan covered these kind of services. The court said it should be paid, and as I said, private insurers can recover the excess of money from the Solidarity Fund. Then, after a while, the regulator extended the health plan to cover for these services. So a case that protected some persons evolved in a reaction by the regulator to expand the health plan to protect HIV and AIDS patients. But it was an exceptional move, I would say. What happened then is that several decisions of the Constitutional Court protecting very important medical services were not followed by the decision of the regulator trying to expand the health plan. And that's why, with the passage of time, we ended up with such structural problems. That's a very tough question. I think that in Colombia we have a design of the Constitutional Court that was conceived to give space to the court to take audacious decisions. I mentioned some features, and then I will highlight other factors that promote legitimacy. First, justices are elected by the Senate. Not nominated by the president, but elected by the Senate. And the Senate in Colombia is elected by a national district all over the country. So, polemically, I say that justices are indirectly elected by popular vote in Colombia. 2/3 of the justices come from the judicial branch, and 1/3 come from lists submitted by the executive to the Senate. So, in a sense, the political forces have a word in the composition of the court. But, secondly, so they feel that they can influence the evolution of constitutional law. Secondly, justices have an 8-year term. And so political forces have the hope of packaging the court every 8 years. Every 8 years they will have a chance to appoint new justices, so they tolerate audacious things for a while. But when the moment comes to elect the new court, it's not easy to pack the court with the election mechanism I mentioned. And until now, since 1992 until 2010, the court has always protected social rights and been very activist in a prudent way, as I said. Third, it is easy to amend the Constitution in Colombia. It's not like approving an ordinary law, but the easiest way to amend the Constitution is to approve a law twice. After being approved, you approve it again, but the second time with an absolute majority of the votes of the member of Congress. So it's relatively easy. It takes more time, and it requires a higher majority. Thus, political forces can try to overrule the court if they do not agree with the judgment. And they have tried several times to overrule the court. Most times they have failed. But it's important because after the court renders a decision, there is a political debate, and the political forces try to have a position on the issue. And if the political forces do not succeed in amending the Constitution to overrule the court, after the debate, there is a strong base of support for the decision of the court. The best case for me is the euthanasia case. The court authorized euthanasia in certain circumstances in the mid-90s. It was a scandal, of course, in a Catholic country. Then there were talks of holding a referendum, and there were amendments introduced in Congress to overrule the court. And at the time, the polls showed that it was a very unpopular decision. Most Colombians were against euthanasia. But last poll I saw, 2/3 of Colombia were in favor. Because of all what I mentioned, all this process evolved in a way that public preferences are shaped in a dialogue, initiated, interrupted, moved by the Constitutional Court. Then there's the other aspect of how the court decides. The court decides following very strict judicial procedures. And the court is very keen in maintaining constitutional due process, if you want. It takes time, it analyzes the evidence, it hears arguments from each side. It's very careful in that. The court wants to be really a judge, not a political actor. And in Colombia, although we had a debate about the government of judges, influenced by the French debate about the government of judges, after the creation of the Constitutional Court, even with the activist Constitutional Court, the word government of judges is absent, I would say, from the political debate, or at least doesn't have the importance it had prior to the 1991 Constitution. And finally, I think that the Constitutional Court has listened, has seen suffering, if you want, in a country where there is lots of suffering. And so Colombians believe that in the court they have a word, they will be valued. And even when the Constitutional Court says you do not have a right, it is accepted. They say, if this Constitutional Court said, I do not have a right, I do not have it. No way, no way. That's why the indigenous came to protect the Constitutional Court.
Just one question. Found properly, I think, a connection. That there is a connection between the rights and the organization. If you have a concentrated authority, rights will suffer, and the culture of rights will not be developed. So I want you to evaluate what the court did in terms of training executive, because I mean, from abroad, one has the perspective that there is a very concentrated authority. That I think affects the culture of
Yes. Concentrated authority in the president. Yes. Yes, we have a very presidential system. I would say that the court has restricted presidential authority in the following ways. First, the court has been very strict in the declarations of states of emergency. Before the 1991 Constitution, we said that Colombia was governed by state of siege. And thus, after 1991, whenever a president declared state of emergency, the court was very strong. And the court held that the president had not total discretion to evaluate the facts that prompted the declaration of an emergency. And thus, several times the court has stricken down the decree that declares the state of emergency. Of course, this is very controversial in the Colombian context. Or the court has stricken down not the whole decree, but some parts of the decree in which the motivations stated by the president could not be demonstrated. The facts that prompted the declaration could not be demonstrated. Or second, when the motives were addressed to structural problems, not to exceptional crises, but to structural problems. So, for example, there was one state of emergency declared because failures in the criminal justice system. Criminals in a country that has lots of terrible criminals were going out of jail. And so the president declared a state of emergency because of that, and the court said, no, you should use ordinary procedures. It's a structural problem in the judicial system. Of course, it's a very terrible problem, but it's structural. So this is the first thing. The second is that the court has interpreted rights even in contexts of executive authority that were used to be thought as spaces where the executive authority had the last word. For example, the court said international humanitarian law must be applied in an internal armed conflict. Thus, from the president as chief of the armed forces to the soldier that is fighting in the armed conflict, there should be respect for international humanitarian law. And this has restricted, of course, executive authority. Third, the court has not allowed a vision of national security, if you want, to inform decision-making concerning public order problems. There was a statute adopted by Congress entitled the National Security Act. It was an act that had this vision. I do not go into details. There should be a National Security Council. In this National Security Council, there should be the president sitting, the president of Congress, the president of the courts, and all should work together against internal enemies. The court struck down this congressional act and said, of course, the state should act against terrorism or violence or whatever you want to name the internal conflict we have, but within a separation of powers, within respect of the political control Congress exercises over the president, and of course, with respect to judicial independence, and no members of the judicial branch can sit in a council where the president heads. And thus the court has been very sensible in concrete cases to how to restrict. Then there is the delegated legislation cases. In Colombia, we had several decrees that regulated matters, very important matters, because Congress adopted statutes saying it is for the president to regulate that. And the court has interpreted these delegation statutes in a very restrictive way. And in the end, this has restricted also executive authority, to mention some of the examples. Yeah. Yeah. Yes. Yes, the Constitution, well, the Constitution uses a language that does not distinguish between positive or negative dimensions of rights, we say in Colombia. But it has a very generous Bill of Rights. And in this Bill of Rights, there are civil, political rights, social rights, economic rights, cultural rights. But I would say that this does not solve the main issues. It is easy for a judge to say these social rights implies public spending. The protection of these social rights requires a public policy to be designed, and I am not a public policy maker. Thus, I urge the competent authorities to do something. Bye-bye, see you. That could be the decision of the judge. Even if social rights are there in the Constitution. And as I mentioned, there have been several important dissents in the court when the court intervenes to protect social rights. So, of course, this has facilitated the action of the court. But I would say that having in the Constitution a clause that says everyone has a right to access a dignified house within the framework established by the legislator does not decide the issue.
Well, just on behalf of BALSA and the entire Northeastern community, we just want to thank you for coming here and speaking with us today, sharing your experience of your country. We truly enjoyed it, and just this is a small token of our appreciation.
All right, thank you. Thank you very much.